conspiracy to commit genocide, direct and public incitement to genocide, attempted genocide, and complicity in genocide. And it is further plausible that South Africa has an obligation to prevent genocide, including by taking all reasonable measures within its powers to influence effectively the actions of persons perpetrating and likely to commit genocide or engaging in direct or public incitement to genocide. So let me be clear. South Africa's obligation is motivated by the need to protect Palestinians in Gaza and their absolute rights not to be subjected to genocidal acts. Notwithstanding the incontestably serious nature of the allegations against Israel, the court should not be required, before granting provisional measures, to ascertain whether the existence of a genocidal intent is the only plausible inference to be drawn from the material before it. That would amount to the court making a determination on the merits. Moreover, South Africa has stressed that any motive or effort by Israel to destroy Hamas does not preclude genocidal intent by Israel towards the whole or part of the Palestinian people in Gaza. Evidence of other motives explaining its conduct as a perpetrator will not save Israel from a finding that it also possessed the requisite genocidal intent. And because of a fundamental feature of genocide, namely that the prohibitions on genocide and associated offences are jus cogens in nature, they are subject, therefore, to no exceptional qualification. They are absolute in nature, in times of war and peace, always and everywhere. Furthermore, the fact that the alleged acts may also be characterized as crimes other than genocide should not exclude the plausible inference of the existence of genocidal intent. As the UN Secretary-General has stated, the prevention of genocide is intrinsically connected to preventing crimes against humanity and war crimes, as these crimes tend to occur concurrently in the same situation rather than as isolated events. Consequently, he said, initiatives aimed at preventing one of the crimes will in most circumstances also cover the others. And as also set out in the ILC articles on state responsibility, the wrongful act of genocide is generally made up of a series of acts which are themselves internationally wrongful. Madam President, honourable members of the Court, South Africa's claims thus concern in the first place its own obligations as a state party to the Genocide Convention to act to prevent and punish genocide. In the application, South Africa has stressed that it is acutely aware of its own obligation as a state party to the Convention to prevent genocide. Indeed, this court has recognized the universal character both of the condemnation of genocide and of the cooperation required in order to liberate mankind from such an odious scourge. As the prohibition of genocide is assuredly a peremptory norm of international law, or jus cogens, it is crucial that states pursue their interest under the Convention in ensuring acts of genocide are prevented. Additionally, due to the special characteristics of the Genocide Convention, the respondent state owes this duty not only to the Palestinian people, but to all states parties to the Genocide Convention, including South Africa. This has been emphasized repeatedly by this court and most recently in the Gambia case, where the court held, and I quote, all the states parties to the Genocide Convention have a common interest to ensure that acts of genocide are prevented, and that if they occur, their authors do not enjoy impunity. That common interest, said the court, implies that the obligations in question are owed by any state party to all the other states parties to the Convention. Similarly, the court has reiterated that in such a convention, the contracting states do not have any interests of their own. They merely have, one and all, a common interest, namely the accomplishment of those high purposes which are the raison d'etre of the convention. Accordingly, any state party to the Genocide Convention, and not only a specially affected state, may invoke the responsibility of another state party with a view to ascertaining the alleged failure to comply with its obligations, erga omnes partes, and to bring that failure to an end. That means that South Africa is asserting both a collective and an individual right. It is thus beyond doubt that South Africa is entitled to invoke the responsibility of Israel under the Genocide Convention. Through South Africa's interest in the common interest, and as a state party to the Genocide Convention itself, it is entitled to safeguard compliance with that instrument. As has been explained, the events unfolding in Gaza at the hands of the Israeli forces are frighteningly unprecedented. Yet what this court is being asked to do in these proceedings, interdicting genocidal acts on an interim basis, is sadly by no means novel. In relation to genocide, the court has indicated provisional measures in analogous circumstances to these in the Gambia case, where, as here, a state sought provisional measures on the basis of the erga omnes right that the Genocide Convention be complied with. Also, in respect of genocide, the court did the same in the Bosnia and Ukraine cases. And most recently, this court further accepted the erga omnes character of parties' rights in relation to the Torture Convention. So South Africa respectfully contends that in this case, the rights of the Palestinians in Gaza are no less worthy of this court's considerable protective power under Article 41 to issue provisional measures. This court cannot but find, as it did in the Gambia case, where this court held that there is a correlation between the rights of members of groups protected under the Genocide Convention, the obligations incumbent on states parties thereto, and the right of any state party to seek compliance therewith by another state party. South Africa's request therefore complies with Article 41 of this court statute and engages the power of this court to preserve by such measures the rights which may subsequently be adjudged by it to belong to either party. South Africa requests this court to discharge that critical protective power, and South Africa does so by virtue of its own clear right and solemn obligations held towards the international community as a whole. For the court to indicate one or more provisional measures, there must also be a link between the rights, the protection of which is sought, and the provisional measure being requested. Such a link manifestly exists, we say, between the rights claimed by South Africa in its application and the provisional measures requested, which are directly linked to the rights which form the subject matter of the dispute. The provisional measures sought therefore ensure the protection of rights which might ultimately form the basis of a judgment in the exercise of the court's jurisdiction in due course. The rights at stake in these proceedings are certainly at least plausible, grounded in a possible interpretation of the Convention, and as the Convention imposes on parties the obligation to prevent and punish genocide under Article 1, and in doing so intends to protect groups and parts of groups from genocide. The Convention was designed to protect both states, parties, and human groups. When acts in breach of the Convention are perpetrated, it is the fundamental rights of people and the relevant group that are violated. Those fundamental rights of Palestinians in Gaza would be the subject of any judgment by this court on the merits. Madam President, members of the court, to find otherwise will not only be to treat Palestinians differently as less worthy of protection than others, it would also be for the court to unduly limit its own competence, to turn its back upon its extensive prior jurisprudence, and to close its eyes to the breach of the rights which lie at the heart of the Convention and which breaches are taking place in Gaza right now as I close. Madam President, I ask you now to call Ms. Negrali KC to the podium, who will address you on a risk of further genocidal acts, the risk of irreparable harm and urgency, and I thank you for your attention.
I thank Professor du Plessis, and I now invite Ms. Binglini Negrali to take the floor. You have the floor, Madam.
Madam President, members of the court, it is a great honor for me to appear before the court once again. It is also both a privilege and a weighty responsibility for me to represent South Africa in this case of such severe gravity. It is my task to examine the urgency and the risk of irreparable harm to the rights claimed, the final two conditions to be met for the Court to indicate provisional measures. Before that, I should like to address South Africa's sincere apologies to the Francophone members of the Court for not having made any of its submissions in French. South Africa would ask you not to regard this as a lack of courtesy on its part. If you will allow, I shall now continue my pleadings in English.
Madam President, members of the Court, there is an urgent need for provisional measures to protect Palestinians in Gaza from the irreparable prejudice caused by Israel's violations of the Genocide Convention. The United Nations Secretary-General and its chiefs describe the situation in Gaza variously as a crisis of humanity, a living hell, a bloodbath, a situation of utter deepening and unmatched horror, where an entire population is besieged and under attack, denied access to the essentials for survival on a massive scale. As the United Nations Under-Secretary-General for Humanitarian Affairs stated last Friday, and I quote, "Gaza has become a place of death and despair. Families are sleeping in the open as temperatures plummet. Areas where civilians were told to relocate for their safety have come under relentless bombardment. Medical facilities are under relentless attack. The few hospitals that are partially functional are overwhelmed with trauma cases, critically short of all supplies, and inundated by desperate people seeking safety. A public health disaster is unfolding. Infectious diseases are spreading in overcrowded shelters as sewers spill over. Some 180 women are giving birth daily amidst this chaos. People are facing the highest levels of food insecurity ever recorded. Famine is around the corner. For children in particular, the last 12 weeks have been traumatic. No food, no water, no school, nothing but the terrifying sounds of war day in and day out. Gaza has simply become uninhabitable. Its people are witnessing daily threats to their very existence, while the world watches on." End quote. The Court has heard of the horrific death toll and of the more than 7,000 Palestinian men, women and children reported missing, presumed dead, or dying slow, excruciating deaths trapped under the rubble. Reports of field executions and torture and ill-treatment are mounting, as are images of decomposing bodies of Palestinian men, women and children left unburied where they were killed, some being picked upon by animals. It is becoming ever clearer that huge swathes of Gaza, entire towns, villages, refugee camps, are being wiped from the map. As you have heard, but it bears repeating, according to the World Food Programme, 4 out of 5 people in the world in famine or a catastrophic type of hunger are in Gaza right now. Indeed, experts warn that deaths from starvation and disease risk significantly outstripping deaths from bombings. The daily statistics stand as clear evidence of the urgency and of the irreparable prejudice. On the basis of the current figures, on average, 247 Palestinians are being killed and are at risk of being killed each day, many of them literally blown to pieces. They include 48 mothers each day, 2 every hour, and over 117 children each day, leading UNICEF to call Israel's actions a war on children. On current rates which show no sign of abating, each day, over 3 medics, 2 teachers, more than 1 United Nations employee, and more than one journalist will be killed, many while at work or in what appear to be targeted attacks on their family homes or where they are sheltering. The risk of famine will increase each day. Each day, an average of 629 people will be wounded, some multiple times over, as they move from place to place, desperately seeking sanctuary. Each day, over 10 Palestinian children will have one or both legs amputated, many without anaesthetic. Each day, on current rates, an average of 3,900 Palestinian homes will be damaged or destroyed. More mass graves will be dug. More cemeteries will be bulldozed and bombed and corpses violently exhumed, denying even the dead any dignity or peace. Each day, ambulances, hospitals and medics will continue to be attacked and killed. The first responders who have spent 3 months without international assistance, trying to dig families out of the rubble with their bare hands, will continue to be targeted. On current figures, one will be killed almost every second day, sometimes in attacks launched against those attending the scene to rescue the wounded. Each day, yet more desperate people will be forced to relocate from where they are sheltering or will be bombed in places where they have been told to evacuate to. Entire multi-generational families will be obliterated, and yet more Palestinian children will become WCNSF, Wounded Child, No Surviving Family, the terrible new acronym born out of Israel's genocidal assault on the Palestinian population in Gaza. There is an urgent need for provisional measures to prevent imminent, irreparable prejudice to the rights in issue in this case. There could not be a clearer or more compelling case. In the words of the Commissioner General of the United Nations Relief and Works Agency, there must be an end to the decimation of Gaza and of its people. Turning to the Court's case law, as the Court has recently reaffirmed, and I quote, "The condition of urgency is met when acts susceptible of causing irreparable prejudice can occur at any moment before the Court makes a final decision on the case," end quote. That is precisely the situation here. Any of those matters to which I have referred can and are occurring at any moment. United Nations Security Council resolutions demanding, quote, "the immediate, safe, unhindered delivery of humanitarian assistance at scale throughout Gaza and full, rapid, safe and unhindered humanitarian access," end quote, remain unimplemented. United Nations General Assembly resolutions calling for a humanitarian ceasefire have been ignored. The situation could not be more urgent. Since these proceedings were initiated on the 29th of December 2023 alone, an estimated over 1,703 Palestinians have been killed in Gaza and over 3,252 injured. As to the criterion of irreparable prejudice, for decades now, the Court has repeatedly found it to be satisfied in situations where serious risks arise to human life or to other fundamental rights. In the cases of Georgia, Russia, and Armenia, Azerbaijan, the Court ordered provisional measures, having found a serious risk of irreparable prejudice where hundreds of thousands of people had been forced from their homes. In ordering provisional measures in the latter case, the Court noted the context of, I quote, "the long-standing exposure of the population to a situation of vulnerability, including hindrances to the importation of essential goods, causing shortages of food, medicine, and other life-saving medical supplies," end quote. In Gaza, as you have heard, nearly 2 million people, over 85% of the population, have been repeatedly forced to flee their homes and shelters, not just once or twice, but some 3, 4, or more times over, into shrinking slivers of land where they continue to be bombed and killed. This is a population that Israel had already made vulnerable through 16 years of military blockade and crippling de-development. Today, Israel's hindrances to the import of food and essential items have brought Gaza to the brink of famine, with adults, mothers, fathers, grandparents regularly foregoing food for the day so that children can eat at least something. Medicine shortages and the lack of medical treatment, clean water and electricity are so great that large numbers of Palestinians are dying or are at imminent risk of dying preventable deaths. Cancer and other services have long shut down. Women are undergoing caesarean sections without anaesthetic in barely functioning hospitals, described as scenes from a horror movie, with many undergoing otherwise unnecessary hysterectomies in an attempt to save their lives. In the Canada-Syria torture case, the court made clear that, I quote, individuals subject to torture and other acts of cruel, inhuman or degrading treatment or punishment are at serious risk of irreparable prejudice. Well, Palestinians in Gaza are also at risk of such irreparable prejudice, with videos of Palestinian boys and men rounded up and stripped and degraded broadcast to the world, alongside footage of serious bodily harm and accounts of serious mental harm and humiliation. In Qatar, United Arab Emirates, the court considered provisional measures to be justified, having regard to the risk of irreparable prejudice deriving from factors such as people being forced to leave their places of residence without the possibility of return, the psychological distress of temporary or potentially ongoing separation from their families, and the harm associated with students being prevented from taking their exams. If provisional measures were justified there, how could they not be in Gaza, where countless families have been separated, with some family members evacuating under Israeli military orders and others staying behind at extreme risk to care for the wounded, infirm and the elderly, where husbands, fathers and sons are being rounded up and separated from their families, taken to unknown locations for indeterminate periods of time. In the Qatar case, the court issued a provisional order where harm to approximately 150 students was an issue. In Gaza, 625,000 school children have not attended school for 3 months, with the United Nations Security Council expressing deep concern, I quote, that the disruption of access to education has a dramatic impact on children and that conflict has lifelong effects on their physical and mental health. Almost 90,000 Palestinian university students cannot attend at university in Gaza. Over 60% of schools, almost all universities, and countless bookshops and libraries have been damaged or destroyed, and hundreds of teachers and academics have been killed, including deans of universities and leading Palestinian scholars, obliterating the very prospects for the future education of Gaza's children and young people. Notably, the court has found provisional measures to be justified in all 3 cases where they were previously sought in relation to violations of the Genocide Convention. It did so in Bosnia and Serbia in 1993, finding on the basis of evidence that was certainly no more compelling than that presently before the court, that it was sufficient to determine that there was, and I quote, a grave risk of acts of genocide being committed. The court found provisional measures to be justified in the Gambia-Myanmar case on the basis of a risk of irreparable prejudice to the Rohingya, subject to, quote, mass killings as well as beatings, the destruction of villages and homes, denial of access to food, shelter, and other essentials of life. More recently, in indicating provisional measures in Ukraine-Russia, the court considered that Russia's military activities had, quote, resulted in numerous civilian deaths and injuries, and caused significant material damage, including the destruction of buildings and infrastructure, end quote, giving rise to a risk of irreparable prejudice. The court had regard to the fact that, quote, attacks are ongoing and are creating increasingly difficult living conditions for the civilian population, end quote, which it considered to be extremely vulnerable. The court also considered the fact that, I quote again, many persons have no access to the most basic foodstuffs, potable water, or intensive scale, to a besieged, trapped, terrified population that has nowhere safe to go. Lest the contrary be suggested, it is clear from Ukraine-Russia that the fact that the urgent risk of irreparable harm arises in a situation of armed conflict does not undermine, much less preclude, a request for provisional measures. That's also clear from the court's other judgments. So in the case of armed activities on the territory of the Congo, for example, the court ordered provisional measures based on its finding that, quote, persons, assets and resources present on the territory of the Congo, particularly in the area of conflict, remain extremely vulnerable, and that there was a serious risk that rights at issue in the case may suffer irreparable prejudice, end quote. Similarly, in Costa Rica, Nicaragua, the court indicated provisional measures in part on the basis that the presence of troops in the disputed territory gave rise, I quote, to a real and present risk of incidents liable to cause irremediable harm in the form of bodily injury or death, end quote. In relation to the Genocide Convention in particular, the court recalled in Gambia, Myanmar, that, quote, states parties expressly confirmed their willingness to consider genocide as a crime under international law, which they must prevent and punish independently of the context of peace or of war in which it takes place, end quote. More recently, in the case of Guyana, Venezuela, the court considered that the serious risk of Venezuela, quote, acquiring and exercising control and administration of the territory in dispute, end quote, gave rise to a risk of irreparable prejudice to the rights asserted in the case. Similar factors are an issue here, having regard to the territorial ambitions and settlement plans for Gaza being raised by members of the Israeli government, and the relationship of those factors to the very survival of Palestinians in Gaza as such. Similarly, any scaling up by Israel of access of humanitarian relief to Gaza in response to these proceedings or otherwise would be no answer to South Africa's request for provisional measures. In the case of Iran, United States, the court found a risk of irreparable harm from the exposure of individuals to danger to health and life caused by restrictions placed on medicines and medical devices, foodstuffs, and other goods required for humanitarian needs. That was notwithstanding the assurances offered by the United States for it to expedite the consideration of humanitarian issues, and notwithstanding the fact that essentials were in any event exempt from the United States sanctions. The court considered that the assurances were, I quote, not adequate to address fully the humanitarian and safety concerns raised, and that there remained a risk that measures adopted by the United States may entail irreparable consequences. In Armenia, Azerbaijan, unilateral undertakings to alleviate restrictions alongside the full resumption of humanitarian and commercial deliveries did not defeat requests for the indication of provisional measures. The court was clear that while contributing, quote, towards mitigating the imminent risk of irreparable prejudice resulting from the military operation, those developments did not remove the risk entirely. Indeed, in Georgia, Russia, the court made clear that it considers a serious risk to subsist where, quote, The situation is unstable and could rapidly change. The court considered, quote, given the ongoing tension and the absence of an overall settlement to the conflict in this region, populations also remain vulnerable, end quote. Israel continues to deny that it is responsible for the humanitarian crisis it has created, even as Gaza starves. The aid it has belatedly begun to allow in is wholly inadequate and does not come anywhere close to the average 500 trucks being permitted daily before October 2023, even under the blockade. Any unilateral undertakings Israel might seek to give about future aid would not remove the risk of irreparable prejudice, not least considering Israel's past and current conduct towards the Palestinian people, including the 16 years of brutal siege on Gaza. In any event, as the United Nations Secretary-General has made absolutely clear, it is a mistake to measure, quote, the effectiveness of the humanitarian operation in Gaza based on the number of trucks allowed in. As he stressed, I quote, the real problem is that the way Israel is conducting this offensive means that the conditions for the effective delivery of humanitarian aid no longer exist. That would require security, staff who can work in safety, logistical capacity, and the resumption of commercial activity. It requires electricity and steady communications. All of these remain absent, end quote. Indeed, only shortly after Israel opened the Kerem Shalom crossing to goods in late December 2023, it was struck in a drone attack, killing 5 Palestinians and leading to another temporary closure. Nowhere and nobody is safe. As the United Nations Secretary-General and all its chiefs have made clear, without a halt to Israel's military operations, crossings, aid convoys and humanitarian workers, like everyone and everything else in Gaza, remain at imminent risk of further irreparable prejudice. An unprecedented 148 United Nations staff have been killed to date. Without a halt to Israel's military activity in Gaza, there will be no end to the extreme situation facing Palestinian civilians. Madam President, members of the Court, if the indication of provisional measures was justified on the facts in those cases I have cited, how could it not be here, in a situation of much greater severity, where the imminent risk of irreparable harm is so much greater? How could they not be justified in a situation that humanitarian veterans from crises spanning as far back as the killing fields of Cambodia, people who, in the words of the United Nations Secretary-General, have seen everything, if they say it is so utterly unprecedented that they are out of words to describe it? It would be a complete departure from the long and established line of jurisprudence that this court has firmly established and recently reconfirmed for the court not to order provisional measures in this case. The imminent risk of death, harm and destruction that Palestinians in Gaza face today and that they risk every day during the pendency of these proceedings, on any view justifies, indeed compels, the indication of provisional measures. Some might say that the very reputation of international law, its ability and willingness to bind and to protect all peoples equally, hangs in the balance. But the Genocide Convention is about much more than legal precedent. It is also fundamentally about the confirmation and endorsement of elementary principles of morality. The Court recalled the 1946 General Assembly resolution on the crime of genocide, which made clear that, I quote, "Genocide is a denial of the right of existence of entire human groups, as homicide is the denial of the right to live of individual human beings. Such denial of the right of existence shocks the conscience of mankind, results in great losses to humanity in the form of cultural and other contributions represented by these human groups, and is contrary to moral law and to the spirit and aims of the United Nations." End quote. Notwithstanding the Genocide Convention's recognition of the need to rid the world of the odious scourge of genocide, the international community has repeatedly failed. It failed the people of Rwanda. It had failed the Bosnian people and the Rohingya, prompting this court to take action. It failed again by ignoring the early warnings of the grave risk of genocide to the Palestinian people, sounded by international experts since 19th of October of last year. The international community continues to fail the Palestinian people, despite the overt, dehumanizing, genocidal rhetoric by Israeli governmental and military officials, matched by the Israeli army's actions on the ground. Despite the horror of the genocide against the Palestinian people being live-streamed from Gaza to our mobile phones, computers, and television screens, the first genocide in history where its victims are broadcasting their own destruction in real time in the desperate, so far vain hope that the world might do something. Gaza represents nothing short of a moral failure, as described by the usually circumspect International Committee of the Red Cross. As underscored by United Nations chiefs, that failure has, I quote, repercussions not just for the people of Gaza, but for the generations to come, who will never forget these over 90 days of hell and assaults on the most basic precepts of humanity. As stated by a United Nations spokesperson in Gaza last week, at the site of a hospital clearly marked with the symbol of the Red Crescent, where 5 Palestinians, including a 5-day-old baby, had just been killed. The world should be absolutely horrified. The world should be absolutely outraged. There is no safe space in Gaza, and the world should be ashamed. Madam President, members of the Court, in conclusion, I share with you 2 photographs. The first is of a whiteboard at a hospital in northern Gaza, one of the many Palestinian hospitals targeted, besieged and bombed by Israel over the course of the past 3 brutal months. The whiteboard is wiped clean of no longer possible surgical cases, leaving only a handwritten message by a Médecins Sans Frontières doctor, which reads, "We did what we could. Remember us." The second photograph is of the same whiteboard after an Israeli strike on the hospital on the 21st of November that killed the author of the message, Dr. Mahmoud Abu Nujayla, along with 2 of his colleagues. Just over a month later, in a powerful sermon delivered from a church in Bethlehem on Christmas Day, the same day Israel had killed 250 Palestinians, including at least 86 people, many from the same family, massacred in a single strike on Maghazi refugee camp. Palestinian pastor Munzar Ishaq addressed his congregation and the world, and he said, and I quote, "Gaza as we know it no longer exists. This is an annihilation. This is a genocide. We will rise. We will stand up again from the midst of destruction, as we have always done as Palestinians, though this is by far maybe the biggest blow we have received." But he said, "No apologies will be accepted after the genocide. What has been done has been done. I want you to look in the mirror and ask, where was I when Gaza was going through a genocide. South Africa is here before this court in the Peace Palace. It has done what it could. It is doing what it can by initiating these proceedings, by seeking interim measures against itself as well as against Israel. South Africa now respectfully and humbly calls on this honourable court to do what is in its power to do, to indicate the provisional measures that are so urgently required to prevent further irreparable harm to the Palestinian people in Gaza, whose hopes, including for their very survival, are now vested in this court.
Madam President, members of the court, I should like to thank you for your kind attention. I ask that you call Professor Lowe, KC, to the podium now to describe the provisional measures sought by South Africa on behalf of the Palestinian people.
I thank Ms. Negrali, and I now invite Professor Von Lowe to address the court. You have the floor, Professor.
Madam President, members of the court, it's a privilege to appear before you and an honour to do so on behalf of the Republic of South Africa. This case is brought under Article 9 of the Genocide Convention, which entitles any contracting party to the convention to submit to the court disputes relating to the interpretation, application or fulfilment of the convention. The court does not at this stage have to determine whether or not Israel has or has not acted contrary to its obligations under the Genocide Convention. That can only be done at the merits stage. It's concerned now only with the question of what provisional measures are required pending the court's final decision on the merits. The court's jurisprudence points to 5 requirements for the ordering of provisional measures. The first is that there should be prima facie jurisdiction, and that was addressed by Professor Donoghue. The second is that there should be a link between the measures requested and the rights underlying the main claim. This requirement is plainly satisfied. The measures request an order that Israel does not violate the very rights secured by the Genocide Convention as set out in South Africa's application. The third is the plausibility of the rights that are claimed. Professor du Plessis explained that this is clearly satisfied. The rights claimed are the very core of the convention, notably the right not to be killed or seriously harmed, and the right of the group not to be physically destroyed. Fourth and fifth, there must be a risk of irreparable prejudice capable of arising prior to the final determination of the dispute, and there must be urgency. Ms. Negrali addressed those points. Israel has, for over 3 months, been mounting a continuous siege and bombardment of Gaza of a ferocity and duration that can only be seen as an attempt to destroy Gaza and its citizens. And it is publicly asserting that it will continue to do so. You are aware of the scale of the death and the scale of the destruction, and it is continuing at this very minute. The court has said that, quote, a state's obligation to prevent genocide and the corresponding duty to act arise at the instant that the state learns of, or should normally have learned of, the existence of a serious risk that genocide will be committed. From that moment onwards, if a state has available to it means likely to have a deterrent effect on those suspected of preparing genocide or reasonably suspected of harbouring specific intent, it is under a duty to make such use of those means as the circumstances permit." End quote. And that is what South Africa has done by making this application. In cases such as Lagrande, Avena, Jadav, this court has exercised its power to order provisional measures, having regard to the impact not only of provisional measures on the state's parties to a case, but also to the impact on the individuals directly affected and their rights. It has issued orders to restrain states from killing individuals in a manner alleged to violate international law. And that is what South Africa is requesting, after more than 23,000 individuals have already been killed in the siege and bombardment of Gaza, the overwhelming majority of them innocent men, women and children. The court also issues orders to safeguard the integrity of its proceedings and the efficacy of its final ruling. In the Bosnia genocide case, for example, you ordered that the parties, quote, "not take any action and ensure that no action is taken which may aggravate or extend the existing dispute over the prevention or punishment of the crime of genocide, or render it more difficult of solution," end quote. Without such non-aggravation orders, there is a real risk that a respondent will rush to complete its unlawful conduct before the court's final ruling, thus rendering the ruling and the court an irrelevance. Well, South Africa has kept its application in this case within the scope of the Convention. First, some will ask why South Africa does not seek any court order against Hamas. This case concerns Israel's actions in Gaza, which is territory that 3 weeks ago in Resolution 2720, the UN Security Council stressed is, quote, "an integral part of the territory occupied in 1967, end quote, by Israel. As the court will understand, Hamas is not a state and cannot be a party to the Genocide Convention and cannot be a party to these proceedings. There are other bodies and processes that can address the questions of steps to be taken in respect of past atrocities and against other actors, and they are no doubt considering what they should do. But as a matter of law, under the Convention, South Africa cannot request an order from this court against Hamas. Secondly, South Africa understands that not all violence constitutes genocide. Acts of ethnic cleansing, collective punishment, the targeting of civilians, attacks on hospitals and other war crimes are all unlawful. But they do not always violate the Genocide Convention. Genocide requires an intent to destroy, in whole or in part, a national, ethnical, racial or religious group. But the fact that what Israel is doing in Gaza may also constitute war crimes or crimes against humanity is no defense and no bar to a charge of genocide. South Africa has set out its request for relief in paragraph 111 of its application and its request for provisional measures in paragraph 144. The reasoning behind the requests is pragmatic. The first two paragraphs of the provisional measures request call for the suspension of Israel's military operations in and against Gaza. Israel's continuing operation in Gaza since the 7th of October attack is the focus of this case. Minister Lamola has recalled the fact that South Africa has condemned the 7th of October attack. Israel says that Palestine and Palestinians are not its target, and that its aim is to destroy Hamas. But months of continuous bombing, flattening entire residential blocks, and cutting off food and water and electricity and communications to an entire population cannot credibly be argued to be a manhunt for members of Hamas. It is an indiscriminate attack, killing, maiming, and terrorizing the entire population of Gaza with no regard to questions of innocence or guilt, obliterating the homes and cities in which they live, and destroying any practical possibility of their return to make their homes amidst the rubble. Israel's actions both attack Palestinians in Gaza directly and also prevents humanitarian relief reaching them. Palestinians face death from continuing bombardments and shootings, and death from starvation and disease, which is even more indiscriminate, but usually slower. In recent days, the United States has said again that far too many civilians are being killed, and the UN Secretary-General and the UN Under-Secretary for Humanitarian Affairs and the Commissioner-General of the UN Relief and Works Agency have asserted that it is imperative to halt military operations in order to enable the effective delivery of humanitarian relief. And that is why South Africa has requested an order for the immediate suspension of Israel's military operations in and against Gaza. It is the only way to secure the humanitarian response and avoid yet more unnecessary death and destruction. There is a point to emphasize. It's no use Israel saying that it does whatever it can to minimize the deaths of innocent men, women, and children. The use of 2,000-pound bunker-busting bombs and dumb bombs in residential areas and the relentless bombardment of Gaza, and even of so-called safe areas to which Palestinians have been directed by Israel, tell another story. But that is not the only point. It's not just a question of scale and of indiscriminate killing. It's also a question of intention. If any military operation, no matter how carefully it's carried out, is carried out pursuant to an intention to destroy a people in whole or in part, it violates the Genocide Convention, and it must stop. And that is why all military operations capable of violating the Genocide Convention must cease. The third request is for an order that both Israel and South Africa, in accordance with their obligations under the Genocide Convention in relation to the Palestinian people, take all reasonable measures to prevent genocide. The fourth and fifth measures then spell out these general obligations in terms of the specific instances of offences listed in Articles 1, 2 and 3 of the Convention. The sixth requested measure addresses the fact that, aside from its own acts, the government of Israel is legally bound to prevent and punish others who engage in or incite or actively support conduct that violates the Genocide Convention. Until the reported intervention of the Attorney General 36 hours ago, Israeli authorities appear to have done practically nothing to stop the flow of genocidal rhetoric, including statements emanating from the ranks of public officials. Indeed, the toleration, even normalization of such incitement has become a matter of concern within Israel itself. And that is why this measure is sought. This case is important. Lives are at stake. Israel's credibility and reputation are at stake. Yet evidence that could determine whether or not particular acts violate the Genocide Convention is being lost or destroyed, while fact-finders and foreign journalists are unable to report freely from Gaza. Hence the seventh request, which is for an order directing the preservation of evidence. And finally, South Africa asks that the court require specific reports from Israel on what it is doing to implement the order. General assurances are not enough. Reports published via the court are an essential element of accountability. I should address the question of self-defence. In its advisory opinion in the Wall case, the court noted that the threat that Israel had argued justified the construction of the wall was not imputable to a foreign state, but emanated from territory, the occupied Palestinian territory, over which Israel itself exercises control. For those reasons, the court decided, as a matter of international law, the right of self-defence under Article 51 of the Charter, the UN Charter, had no relevance in such circumstances. 20 days ago, the Security Council affirmed yet again that Gaza is occupied territory. Though Israel refers to a complete withdrawal from Gaza, it has retained control over Gaza, over access by land and sea and air, and over key governmental functions and supplies of water and electricity. The tightness of its grip may have varied, but no one can doubt the continuous reality of Israel's grip on Gaza. The court's legal holding from 2004 holds good, and a similar point is to be made here. What Israel is doing in Gaza, it is doing in territory under its own control. Its actions are enforcing its occupation. The law on self-defence under Article 51 of the UN Charter has no application. But that is not the main point. The main point is much simpler. It is that no matter how monstrous or appalling an attack or provocation, genocide is never a permitted response. Every use of force, whether used in self-defense or in enforcing an occupation or in policing operations or otherwise, must stay within the limits set by international law, including the explicit duty in Article 1 of the Convention to prevent genocide. South Africa believes that the publicly available evidence of the scale of the destruction resulting from the bombardment of Gaza and the deliberate restriction of food, water, medicines and electricity available to the population of Gaza demonstrates that the government of Israel, not Jewish people or Israeli citizens, the government of Israel and its military is intent on destroying the Palestinians in Gaza as a group and is doing nothing to prevent or punish the actions of others who support that aim. And I repeat, the point is not simply that Israel is acting disproportionately. The point is that the prohibition on genocide is an absolute, a peremptory rule of law. Nothing can ever justify genocide. No matter what some individuals within the group of Palestinians in Gaza may have done, and no matter how great the threat to Israeli citizens might be, genocidal attacks on the whole of Gaza and the whole of its population with the intent of destroying them cannot be justified. And no exception can be made in a provisional measures order to allow a state to engage in actions that are capable of violating its obligations under the Genocide Convention. It is unthinkable that a court would ever do such a thing. That is the simple point in this case. Genocide can never be justified in any circumstances. Israel's actions will be examined closely and methodically at the merit stage, when the court will want to hear what Israel has to say in its defense. What matters now is that the evidence indicates that Israel's actions have violated its obligations under the Genocide Convention, that they continue to violate them, and that Israel has asserted that it intends to continue them. Israel may say that it will comply with all of its obligations under the Genocide Convention and that orders from the court are not necessary. But in previous cases, the court has held that such unilateral statements do not remove the risk of irreparable prejudice or obviate the need for a court order. In this case, one reason for doubting the efficacy of any such unilateral undertaking is Israel's apparent inability to see that it has done anything wrong in grinding Gaza and its people into the dust. Another reason is that a departure from or reinterpretation of any unilateral undertaking by Israel may lead to consequences so appalling that the risk simply cannot be taken. But there is a third reason. As was noted during the submissions to this court in the case concerning the reservations to the Genocide Convention in 1951, quote, "The obligation to submit disputes concerning the interpretation or execution of the Convention to the International Court of Justice was regarded as one of the prime guarantees of the due fulfillment of the basic obligation to prevent and punish the crime of genocide," end quote. The role of the court, which unusually extends not only to the interpretation and application of the Convention, but also to its fulfillment, is pivotal. In addition to their substantive obligations under the Convention, it is vitally important that states respect the court and their procedural obligations. This is not a moment for the court to sit back and be silent. It's necessary that it assert its authority and itself order compliance with the obligations under the Genocide Convention. Indeed, it's hard to think of a case in recent history which has been so important for the future of international law and of this court. Madam President, members of the court, that concludes my submission. I thank you for your attention, and unless I can help you further, I would ask that you call on South Africa's agent to read out the request for relief.
I thank Professor Lowe, and I now invite the agent of South Africa, His Excellency Mr. Vusumuzi Madonsela, to address the court. You have the floor, Excellency.
Madam President, it remains my honor to read to Your Excellencies the provisional measures that South Africa requests from the court. You have heard the reasons set out which justify the measures being sought. To sum up, the indication of provisional measures is, we recognize, without prejudice to the merits of the underlying claim. Yet, the evidence at this stage indicates grave violence and genocidal acts against the Palestinians in Gaza, in flagrant contravention of the Genocide Convention and in breach of their rights. South Africa has come to this court to prevent genocide and to do so in the discharge of the international obligation that rests on South Africa and all other states under the convention. The consequences of not indicating clear and particularized specific provisional measures and not taking steps to intervene while Israel disregards its international obligations before our eyes would, we fear, be very grave indeed for the Palestinians in Gaza, who remain at real risk of further genocidal acts, for the integrity of the Convention, for the rights of South Africa, and for the reputation of this court, which is equipped with and must exercise its powers to afford an effective realization of the rights under the Convention. That means we respectfully submit, indicating the provisional measures being sought by South Africa, as well as any others in addition which the court might deem appropriate. Justice and equal respect for the rights of Palestinians points overwhelmingly in favor of these critically required provisional measures. Madam President, I now proceed to read the measures requested by South Africa. On the basis of the facts set forth above, South Africa, as a state party to the Convention on the Prevention and Punishment of the Crime of Genocide, respectfully requests the courts, as a matter of extreme urgency, pending the court's determination of this case on the merits, to indicate the following provisional measures in relation to the Palestinian people as a group protected by the Genocide Convention. These measures are directly linked to the rights that form the subject matter of South Africa's disputes with Israel. 1. The State of Israel shall immediately suspend its military operations in and against Gaza. 2. The State of Israel shall ensure that any military or irregular armed units which may be directed, supported, or influenced by it, as well as any organizations and persons which may be subject to its control, direction, or influence, take no steps in furtherance of the military operations referred to in point 1 above. 3. The Republic of South Africa and the State of Israel shall each, in accordance with their obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, in relation to the Palestinian people, take all reasonable measures within their power to prevent genocide. 4. The State of Israel shall, in accordance with its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, in relation to the Palestinian people as a group protected by the Convention on the Prevention and Punishment of the Crime of Genocide, desists from the commission of any and all acts within the scope of Article 2 of the Convention. In particular, A, killing members of the group, B, causing serious bodily or mental harm to the members of the group, C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and D, imposing measures intended to prevent births within the group. 5. The State of Israel shall, pursuant to point 4, paragraph C above, in relation to Palestinians, desist from and take all measures within its power, including the rescinding of relevant orders, of restrictions and or prohibitions to prevent A, the expulsion and forced displacement from their homes, B, the deprivation of access to adequate food and water, access to humanitarian assistance, including access to adequate fuel, shelter, clothes, hygiene and sanitation, the medical supplies and assistance, and C, the destruction of Palestinian life in Gaza. Number 6, the State of Israel shall, in relation to Palestinians, ensure that its military, as well as any irregular armed units or individuals which may be directed, supported, or otherwise influenced by it, and any organizations and persons which may be subject to its control, direction, or influence, do not commit any acts described in 4 and 5 above, or engage in direct and public incitement to commit genocide, conspiracy to commit genocide, attempt to commit genocide, or complicity in genocide. And insofar as they do engage therein, that steps are taken towards their punishment pursuant to Articles 1, 2, 3, and 4 of the Convention on the Prevention and Punishment of the Crime of Genocide. Number 7, the State of Israel shall take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of Article 2 of the Convention on the Prevention and Punishment of the Crime of Genocide. To that end, the State of Israel shall not act to deny or otherwise restrict access by fact-finding missions, international mandates, and other bodies to Gaza to assist in ensuring the preservation and retention of said evidence. Number 8, the State of Israel shall submit a report to the court on all measures taken to give effect to this order within 1 week, as from the date of this order, and thereafter at such regular intervals as the court shall order, until a final decision on the case is rendered by the court, and that such reports shall be published by the court, I beg your pardon. Number 9, the State of Israel shall refrain from any action and shall ensure that no action is taken which might aggravate or extend the dispute before the court or make it more difficult to resolve. Thank you, Madam President and distinguished members of the court. That concludes South Africa's address. Thank you.
I thank the agent of South Africa, whose statement brings to an end the single round of oral argument of South Africa, as well as this morning's sitting. The court will meet again tomorrow, 12 January 2024 at 10 a.m. to hear the single round oral argument of Israel. The sitting is adjourned. South Africa, as well as this morning's sitting. The court will meet again tomorrow, 12 January 2024 at 10 a.m. to hear the single round oral argument of this week. The sitting is adjourned.
You are watching Al Jazeera, and the court adjourns in the Hague, the International Court of Justice, presided by Donoghue, the judge from the United States, 15 permanent members of that court, plus a judge from South Africa and a judge from Israel, sitting 17 of them now adjourned until tomorrow, when they will then reconvene to hear Israel's side of the story and their case and rebuttal of the petition made by South Africa. Let's join Thomas McManus, Director of International State Crime Initiative at Queen Mary University, joins us from London. Thank you for being so patient. I know it's been a very long process this morning, and we've been dipping in and out of your comments as we've gone. I wouldn't mind getting an overview of...
Free Palestine! Free Palestine! Free Palestine! From the river to the sea! Palestine will be free! Palestine will be free! From the river to the sea! End that complicity! End that complicity! Free Palestine! From the sea to the river! Palestine will live forever! Palestine will live forever! From oppression to liberation! From oppression to liberation! We will end the occupation! We will end the occupation! Occupation down, down! Occupation down, down! Liberation up, up! Liberation up, up! Palestine up, up! Israel down, down! Israel down, down! Israel down, down! From the river to the sea! Palestine will be free!
کردن با این آسیون با این اعتراض همبستگی کردن حضرت تمدیده و زمین خویش فلسطینی علیه نتانیاهوی جنایتکار صهیونیسم اشغالگر و درد کننده حقوق بشر.
Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now! Ceasefire now!
Free Palestine!
Free Palestine!
1, 2, 3, 4!
1, 2, 3, 4!
Occupation no more!
Occupation no more!
5, 6, 7, 8!
5, 6!
You know that you're all okay. Why do you see outside again? Maybe this is the day for him. Look, this is the highway. Soon now the train is on. So this is the move wherever you want, you know? Maybe, I don't know, if the traffic is really busy, you can stand a bit clear and keep it.
C'est comme ça va? Ça va bien? Oui. C'est bon?
I will turn it on.
Si jamais واحدين يتكلموا منه ومنه ممكن.
No, that's fine. Yeah. Yeah? Yeah, it's more focus, huh? Yeah, I was So if the guys are far away, just go in front and then we'll...
Well, we have just listened to the very
Je pense que je dois passer là-bas. Voilà, maintenant. المشكلة c'est que
No, it's on.
injunction. So what they are asking for an historian the ICJ for many years. Most recent, most gruesome case so far compared to previous genocide.
Sorry, lady. Sorry. Sorry. Madame.
So this is a very strong case, they say, and we're waiting now for a press conference
This is really bad.
by the validation that the Minister of Justice is about to speak behind the
it's going to come there with some
delegation and also expected.
they should be down there, they should be down there for the
So a lot of citizens also.
Oh, great. Okay.
Pardon?
Tu peux pas les détendre plus de la perche?
Non, celle-là quand même. Il faudrait que tu ailles devant en fait. Hein.
You did a pretty good job. No, it's funny, like this government, I think you will have to go there in front of the... Let's see now what happens, but just go there. Yeah, they can do that. But you know, it's remove it later and just get close. When they come, the road go down. Yeah, better.
Il faut la ranger encore.
Tu la ranges chez toi ou pas?
C'est pour moi.
Mike.
Uh-oh.
All these guys can get.
I like the hairband. Who's the hairband? Who's the woman with the loose hair now?
No. Oh, hey, no, it'll break. It'll break. Too much weight now.
Hang on. It's actually too balanced on that side. May I hang it on this side? Like that? I'll show you. Yeah, we'll move it over.
I think you guys we should move all the way up, huh? That's the easiest way.
It's too close, yeah?
Yeah,
you gotta move this thing up, right?
Anyway,
yeah, but low, right?
Yeah, well, that's one screw will wait. Lower? Nah.
Get them together, man.
Higher, I think.
So which knee you got?
Non, c'est par là. C'était au milieu.
Ah, ça, c'est le milieu.
Non, le milieu de la porte. C'était le milieu de la porte. Quand il sort, il vient directement.
Quand même. Les micros étaient ici, tu les enlèves de là.
Mais il n'est pas à jour, donc c'est au milieu de la porte.
Et tu nous obliges à nous déplacer là-bas, donc ça va être...
On a dit.
On était encore un peu comme il était. Encore un peu.
Non, parce qu'à ce moment-là, tu vas provoquer le cohue.
Ça va?
Encore. Encore.
Ouais, c'est bien maintenant.
Voilà.
Non, c'est bon. Si tu ne vas pas le déplacer, on va aller, on va foutre le bordel pour tout le monde. Donc c'est mieux que de ne pas toucher les micros.
Si c'était en bas, c'est mieux.
There's like this whole group of cameramen over there.
Yeah, but it was there.
True, and I'm right there. But I'm not the problem. But if you want to make enemies in that corner,
No, but you are responsible for your microphone, not for our microphone.
true. But I'm trying to accommodate everybody here, which includes the people standing over there. I don't have a problem. I'm there, so it could be here, but there's colleagues over there. Just saying.
He's great, eh? He's unbelievable.
Ouais, il dira samedi matin. Non. Ok, je dirais samedi matin.
Just assembling the team. We should be ready in the next 10 minutes later. Apologize for
Monsieur Mélenchon? Monsieur Mélenchon?
instead of outside.
Here.
Écoute, je sens là.
Monsieur Mélenchon?
Ok, bye.
مرزوق يسلم عليك ولا ما عرفت.
Yeah, you're right in there, yeah. Down, yeah. Hello there, how are you? What? Prime position, sir. I'm doing well. I mean, it's getting a bit crowded now, Dev.
Il est possible, Johnny, il est possible que tu parles ici et à l'extérieur. Hein. Mais bon,
ça y est, tu peux plus.
Mais donc dans ce cas-là, you drop something. You just drop something.
Ah,
mais dans ce cas-là, bon, on prend le réponse de la vie.
It's supposed to be hot, right?
Ah. Soms temperatuur van weten. Nee, of Nederlands. Sorry.
אתה מדבר על מישהו שנמצאת בהאג או אצלכם? כי אנחנו בשש שעות, מסיבת עיתונאים של נציגי המשפחות שהגיעו לכאן. זה התחיל בדיוק ב-6:00, אז אנחנו נהיה שם.
Try to get you, Mr. Coburn qui est là. Yeah. Yeah. Yeah, it's our bread.
Het makkelijker zijn dan zou ook zijn.
Corbin. Is it Corbin? Where is he? Ah, can you just Johnny?
Oh no, in Pakistan. Elle est là. Oui, elle est ici.
Sorry.
I didn't realize you had your hair. Yeah, remote there. Oh, yeah, that's good. Ja, dat is het. Ja, de enige manier dat het zo heel blij dat je nu. Ja.
It's not like this one.
Maybe he will join the crowd. He belongs to this group. Sorry, I'm keeping you on.
Sorry, no, don't worry. الفلسطيني وزير الخارجية.
They were surprised hearing this
Oui, mais il y en a plein qui sont rentrés dans un véhicule qui est parti, donc c'est pas qui va venir parler.
La voiture est partie.
Ouais.
Mais qui va venir
Je sais pas.
Parce que pour le coup, c'était toute la voiture légale.
Ouais, c'est ça. À mon avis, ça va être l'extérieur.
Once they're here, I'll bend it.
It's amazing the things fighting with the school at the moment, so it's got to stop them to do some of the
say something.
C'est parce que... Pardon? L'âge de restitution, ça sert à rien. Mike, just a bit. Do you have her name?
Not totally.
I think you will have to sit on the stair and together. She's outspoken also.
Yeah, I'll have the live outside.
It's perfect, Mike. Thank you.
So you don't have to hire them to outside, or you have your time? No, but I'm here. But we do it here, why outside? It might be outside, because I think they're going to tell us to go out. Okay, but I'm here. Then we will come with you. Perfect. Yes, no problem. You can come here in Taranto. Yeah. I think it gets this way. No, don't worry. I'll make this down.
You went inside, eh? So probably he will step out like the others. There is also Mayor of Barcelona. Yeah, I have her on camera, maybe she will also say something. That will be interesting, yeah. Thank you, house. Yeah, his family leaving. I think we all read about it. I don't know. Yeah, preaching people. What to do? Yeah, every good job I will tell you how to behave. 15 years. Yeah, of course.
יש לך עוד דברים בזה, בינה? יש עוד דברים בפרסום? כן. אני רוצה שאנשים יוצאים, כדי שלא... משהו מקורבים? משהו טוב, לגבי הראשי
Trying to avoid my call.
No? See,
If you put it down there, you cannot.
Yeah, that would be good.
Away from these, not happy about it. No.
إذا وصل المتحدث أنا مضطر أقطع. أوكي. موجود الإشارة عندك على 3G. والآن بعدين الإشارة موجودة.
They're coming, huh?
No, just to be sure.
You have to come down, huh, please.
To the mic, please. Sorry.
Can you come down to the mic? Coming down.
Is
it fine? Okay, welcome ladies and gentlemen to the press conference of the Republic of South Africa. Flanked next to me is the Minister of Justice and Correctional Services for the Republic of South Africa, and we will also have our Director General for the Department of International Relations, and behind him is the Director General for the Department of Justice and Constitutional Development, and to my right is our ambassador to the Netherlands, and we're also joined by our Palestinian friends. Over to you, Minister Lamola.
Thank you very much. The government of the Republic of South Africa, led by His Excellency President Matamela Cyril Ramaphosa, entrusted me with representing its commitment to the rule of a just law and to confirm and assert a universally rule-based society and the respect for human rights, and specifically the rights of the Palestinian people to sovereignty, to peace and to life. We want firstly to thank our excellent legal team for an able presentation at the court. We also want to thank the court for granting the government of the Republic of South Africa an opportunity to present its case in real time. We hope that its decision will also be impactful to the people of Gaza and Palestine in general. Since the advent of our democracy in 1994, South Africa's foreign policy has been based on what our forebears inscribed in the Freedom Charter in 1955, when they declared that South Africa shall be a fully independent state with respect the rights and the sovereignty of all nations. South Africa shall strive to maintain world peace and the settlement of all international disputes by negotiations and not war. Close quote. South Africa has supported various resolutions of the United Nations and other international solutions to support a just and a lasting solution that will bring peace to the Palestinians and Israelis alike. Working together with the international community and in alignment with the relevant UN resolutions and international law, South Africa seeks to ensure a lasting and a durable peace that produces a viable, contiguous Palestinian state, coexisting side by side in peace with Israel, within the 1967 international recognized borders, with East Jerusalem as its capital. Our President has called for a ceasefire and humanitarian interventions on numerous occasions. Our foreign policy is aimed at improving the well-being, safety and prosperity of all citizens and the achievements of a better Africa and the world. The key pillars of our foreign policy include the promotion of human rights, peace and stability, and the strengthening of trade and investment ties with other countries. The world has watched in horror as Palestinian men, women and children were slaughtered, blown up, buried alive under the rubble of their homes, left to die painful deaths in unresourced hospitals, resulting in over 23,000 deaths through destruction to homes, schools, hospitals, water, treatment plants, and other public infrastructure that impairs the conditions of life and is calculated to bring about the destruction in whole or in part of the Palestinians living in Gaza. South Africa has unequivocally condemned the attack by Hamas on the 7th of October, and it has also done so in its note verbal to the State of Israel, conveying its condemnation of that action of Hamas on the 7th of October. And South Africa has reiterated here in court that those atrocities are no justification for any form of genocide. With the recent escalation of the aggression of Israel in Gaza, South Africa has supported a number of UN resolutions calling for immediate ceasefire and the provision of humanitarian aid to the people of Palestine. Sadly, the world has not succeeded in stopping the genocide that is currently unfolding in Gaza. The international community has largely remained passive in response to these atrocities. Women and children in areas such as refugee camps, schools, and hospitals have been targeted, leading to a humanitarian crisis. We also unequivocally call the United Nations Secretary General invoked a rarely used article of the UN Charter, Article 99. The Secretary General Antonio Guterres on the 6th of December 2023 called on the Security Council to press to avert a humanitarian catastrophe in Gaza and unite in a call for a full humanitarian ceasefire between Israel and the Palestinian militants. This plea of Ubuntu, a plea for humanity of the international community to prevail, was simply ignored. Israel's institutional impunity was reinforced. In keeping with our obligation as a state party to the Genocide Convention, our government has approached the International Court of Justice to prevent the unfolding genocide in Gaza. We have also asked for provisional measures which include an immediate suspension of Israel's military operations in and against Gaza. The commitment to justice and bring an end to the humanitarian atrocities in Palestine resonate deeply with the collective consciousness of the global community. The scale of these actions is reminiscent of the Rwandan genocide 30 years ago. We are here on behalf of South Africa and the global community to seek justice for the victims, particularly children, women, and the elderly. We believe that without the intervention of this court, of the international community, we will see the total destruction of the Palestinian people in Gaza. Remaining silence in the efficacy of this and in and of itself will be a gross violation of international law. As a state party to the Genocide Convention, we have a duty to prevent genocide. We are seeking the court to intervene and stop the ongoing massacre in Gaza. Today, it is common cause that the Rwandan genocide could have been prevented. Former UN Secretary General Kofi Annan expressed this regret when he said, and I quote, "The international community failed Rwanda, and that must leave us always with a sense of bitter regret and abiding sorrow." Close quote. Rwanda stands out as a stern and severe rebuke to all of us for having failed, for the international community having failed to prevent it from happening. Let us not have it live with the same regret when it comes to Palestine. This case presents the court with an opportunity to act in real time to prevent genocide from continuing in Gaza by issuing an urgent injunction. South Africa is multifaceted, multicultural, and a multiracial country that embraces the concept of Ubuntu as a way of defining who we are and how we relate to others. Ubuntu means I am because you are. I am because Hamza Abdullah is. You are because Duna Ab Mozen is. The philosophy of Ubuntu means humanity and is reflected in the idea that we affirm our humanity when we affirm the humanity of others. It has played a major role in the forging of South African national consciousness and in the process of its democratic transformation and nation building. Our history is one of repression and violence, human rights abuses, apartheid as a crime against humanity, discrimination and distrust between people born on the same soil. This history enjoins us to stand in principle in solidarity with the people of Palestine, as of our founding father would have wanted us to do, Nelson Mandela. Because our history is one marked by crimes against humanity, the recent horrific scenes of the city of Gaza being transformed into mass burial ground haunt our minds. The alarming sight of jubilant armed forces rejoicing to the chance who are finishing off Gaza is an act among several others that warrant a thorough examination by this honorable court. The words of Israel ministries, Israel members of parliament, the generals of the army, speeches such as calling people of Palestine human animals shows a clear statement of intent to wipe out the Palestinian people out of Gaza. The UN Committee on the Elimination of Racial Discrimination stated that such language is an incitement to genocide and underscored the importance of preventing genocide by all state parties. As a signatory to the convention, we also have a duty to bring this matter to the court's attention and to stop genocide. The actions taken by Israel against Palestinians are considered by many state parties, including the state of Palestine itself, to be in breach of the convention. Palestine has expressed grave concerns over the international system's incapability to prevent acts of genocide against its people and has urgently called for an action to halt such acts. The uncompromising enforcement of the rule of law must be used to cease the ongoing atrocities in Gaza. This case also is about the assertion and the affirmation of the international rule of law and to end exceptionalism when it comes to the state of Israel. Our distinguished legal team has expanded on our case in the court. We want to conclude with the words of Martin Luther King when he said, and I quote, "The arch of the moral of the universe is long, always bending towards justice." We believe justice will prevail in this court. Thank you very much.
Thank you, sir. Can you tell us what difference you think this case will make on the ground?
It will make a huge difference, the fact that the state of Israel is held to account by the international community. The soldiers, they know, the authorities in Israel, they know that if they continue, they may one day be called even before the ICC individually and be held accountable. So the message is clear: they must cease, they must desist from the acts of genocide.
Minister, how confident are you that the court will actually pronounce these provisional measures against Israel?
Obviously, we cannot want to overtake the court's role and also second guess the court. We believe that we've presented a compelling case, facts, and the law, international law. There is clear jurisprudence with regards to the case and the facts that we've presented. As you have heard, our lawyers have also quoted extensively on international jurisprudence. That is where we stand on, and we will continue to allow the court to examine the facts and come up with a verdict. It's not for us to pronounce on behalf of the court.
Minister, how do you respond to that?
Minister, there's often a statement made by many countries, particularly those who are sympathetic to Israel, that those Western powers who are sympathetic to Israel are likely going to punish South Africa. What is South Africa's position in relation to perhaps a fallout that is likely going to ensue?
Zain. Thank you, Sophie. I will take that question. We have engaged with many of the countries that you've mentioned. Many of them understand that we take diametrically different positions to them. Our position is on Palestine, as the ministers pointed out and as our legal team has pointed out, is based on principle. So we can defend our position with all of them. And in fact, we're doing this in the interest of securing justice for Palestinians, but it's also to ensure that international law, as you pointed out, is implemented fairly and also evenly, and that is in the interest of preserving international law for all. Zain Dango, Director General of International Cooperation.
Minister, do you recognize any responsibility by Hamas to the situation happening now in Gaza?
As we have said in court, we have condemned the action of Hamas on the 7th of October, and we have done so also through a note verbal to the State of Israel.
Minister, when do you expect the decision of the court? Is it a matter of days or a few weeks? When do you expect that?
Yeah, obviously we want to not to preempt the court, not to put unnecessary pressure on the court, but we believe the court has heard our side they understand the agency, and they will deliver the verdict within reasonable time.
Political support from other countries.
Commented that South Africa is the legal arm of Hamas. How do you respond to that?
Yeah, we have presented a case here on behalf of the government of the Republic of South Africa, and we are doing so on behalf of a number of Palestinians, young kids, women, and the elderly that are being killed in Gaza. We are not presenting any case on behalf of Hamas. So that statement is baseless. That statement has got no merit. We do not have any mandate from Hamas. Our mandate is from the South African government, and our case also is not against the Jews as a people. Our case is against the actions of the state of Israel, the actions of genocide that are committed in Gaza. In South Africa, we have got a number of Jewish people doing business, living with us, and they also attend their churches in peace. So the case is about the state of Israel. It's not about the Jewish people as a community.
You have no contact with Hamas people by other countries in African Union or in Asian countries or Latin American
You have already asked the question.
Can I ask, Israel says you're playing politics with this and it has a right to self-defense. What's your response?
This is the highest organ of the UN. I think it will be an insult to the court to say that the court granting us an opportunity to present our compelling case that all of you have seen, citing international law, providing facts, and citing the relevant articles of the convention, Article 1 of the convention, and a number of UN conventions that the court has been presented with. So we have presented a compelling legal argument. This is not politics. We're expecting the court to pronounce on the facts and on the law.
And what should happen to Israel if it ignores the outcome?
Did you?
About the diplomatic relations with Israel, will you maintain them?
So obviously currently our diplomatic relations is not normal. You've seen that we have recalled our ambassadors from Israel, and Israel has also recalled their ambassador from South Africa.
Left many years ago already.
Yes, and we've also recalled our entire team. In essence, what we are saying is that we will wait for the outcome of this court case, but also for justice to be found within Palestine, and we hope that after that we can engage with Israel as with other stakeholders towards a just and lasting peace for both Palestinians and Israelis.
So you will decide on the fate of the relations after the court issues?
I think we'll be able to engage with our relations a lot more openly after the court case has been concluded.
And Minister, what if the court doesn't agree with you? Would that lead to South Africa questioning this system itself?
Yeah, we are here to assert the international rule of law. This is the highest organ of the UN. We believe that the judges are professionals. We are cognizant of the reality of an international court in this jurisdiction and how it's functioning. But they've taken an oath, and we want to give them the benefit of a doubt that they will be able to exercise professionally. And that's why we presented the case, citing facts, citing jurisprudence, citing the necessary conventions of the UN.
But Minister, do you honestly believe that the Israelis want to wipe out the Palestinians of Gaza? Do you personally believe that?
Yes, we do.
Do you have any contact?
The Palestinians can speak on that.
At any point?
I want to say a statement.
Yes.
Yeah. Well, you want to go ahead?
Yes.
Excellency. Well, first of all, I think the facts speak for themselves. What Israel is doing in Gaza Strip is obvious based on fact and law, that they are wiping the people of Gaza and forcibly and putting the population there in conditions that will lead to their demise. Allow me to say a few words in Arabic on behalf of the state of Palestine, and then to make a short statement also in English. دولة فلسطين تثمن عاليا وتقدر وتدعم بلا تحفظ الخطوة التاريخية التي أقدمت عليها جنوب أفريقيا تنفيذا لالتزاماتها بموجب اتفاقية منع الإبادة الجماعية والمعاقبة عليها، وتحريكها لدعوة ضد إسرائيل السلطة القائمة بالاحتلال نتيجة حرب الإبادة الجماعية التي ترتكبها ضد الشعب الفلسطيني في غزة. لقد وضعت النقاشات اليوم المحكمة والتي تقدمت بها جنوب أفريقيا، المحكمة والعالم، بصورة الجرائم التي ترتكب بحق الشعب الفلسطيني والتي تفضي إلى ارتكاب جريمة الإبادة الجماعية، ولكن أيضا في السياق التاريخي الأشمل للقضية الفلسطينية والجرائم التي ترتكب بحق الشعب الفلسطيني، بدءا من النكبة والاستعمار ونهب أرضه والتمييز العنصري وكل ما إلى ذلك من انتهاكات كانت ترتكبها إسرائيل على مدار 75 عام. هذه لحظة تاريخية للشعب الفلسطيني وللإنسانية وكذلك للنظام الدولي المبني على والقائم على القانون. نتقدم بالشكر لكل الدول التي ساندت هذا الطلب، وندعوها أيضا ندعوها للقيام واتباع الخطوة الشجاعة التي قامت بها جنوب أفريقيا ودعمها من خلال الدخول في مرحلة النقاشات التي تناقش تفاصيل القضية لاحقا. أخيرا نؤكد أن لا أحد يمكن له الادعاء بعدم معرفة والجهل بالجرائم التي ترتكبها إسرائيل بحق الشعب الفلسطيني، وستواصل القيادة الفلسطينية ودولة فلسطين سعيها لإحقاق الحق الفلسطيني وتنفيذا لكل الحقوق الفلسطينية ومساءلة كل الجرائم التي ارتكبت بحق الشعب الفلسطيني. Allow me to say a few words in English and I'll try to make it short. I know you've been waiting for long. Sorry to make you wait for that long. But we thank you for being here with us in this historic day, not only for Palestine, but for humanity and for the whole international rules-based system. The state of Palestine values and appreciates wholeheartedly the historic action taken by South Africa today at the highest international court. As a party to the Genocide Convention, South Africa has acted in pursuance of its obligations and duty to prevent and punish the crime of genocide by requesting the ICJ to intervene to suspend the genocidal war launched by Israel against the Palestinian people in Gaza. Very importantly, the South African oral argument also presented the context in which this genocide is happening, a continuum of Nakba, of colonization, of dispossession, oppression and apartheid that the Palestinian people have been suffering from for the past 75 years. South Africa presents a damning evidence confirming that Palestinian people have suffered and are suffering irreparable harm from Israel's violation of the Genocide Convention. This is a pivotal moment for the international system. South Africa took a bold and proactive step on behalf of humanity to protect the Palestinian people and ensure that the Genocide Convention and international law do not become completely irrelevant, which is a prospect that must terrify all of us. Nearly 100,000 Palestinians have been killed, disappeared under the rubble and injured by Israelis over the past 3 months. Israel caused systematic, extensive and deliberate destruction of the foundations of life in Gaza, including homes, infrastructure, hospitals, churches, mosques. Israel displaced nearly the entire population and is deliberately starving the population. Israel is destroying the foundations of life in Gaza. We thank all states and intergovernmental organizations who supported this important and historic step by South Africa. We also urgently call on all states to take steps to support South Africa's application. And let me be clear, no one can claim plausible deniability that thanks to at least the 115 colleagues of yours that have been killed by Israel in the course of the 3 months that passed. The Palestinian leadership will not relent until our rights of return, freedom and independence are achieved. Humanity is at crossroads. The case before the ICJ is a test to the international system. It is a moment of naked truth and an opportunity to provide hope to humanity at a time when it's sorely needed. Leaders have a historic responsibility and their actions will be judged by history. Thank you.
Could you say your name, please?
Sorry, I did not introduce myself. My name is Ammar Hijazi. I'm the Assistant Minister of Foreign Affairs of the State of Palestine.
Thank you very much.
Thank you.
Are you representing also Hamas people?
Are you representing this was all about? What we expect tomorrow is that Israel will also present its case at a very late court. We expect Israel to bring outside the court, where you have also international representatives, among them the former leader of the Labour Party in the United Kingdom, Jeremy Corbyn, who I spoke to earlier on, and he was full of praise in terms of how South Africa has.
Shall we do your mobile phone? I gotta go to the store.
And use the Joker. You were asking the name, no? Yeah.
Yeah, please. Can you?